Great. Welcome, everyone. Welcome to our Judicial Candidates Forum. We have some Brooklyn district leaders here. We're going to do some quick introductions. Hi, everyone. My name is Julio Peña. I'm a district leader in the 51st Assembly District, representing Sunset Park, Bay Ridge, parts of Park Slope, Red Hook, and Gowanus. And I'm going to pass it to my district leader up north, Christina.
Hi, everybody. Thanks, Julio. My name is Christina Naplatarski. I'm the female district leader from the 50th Assembly District, so representing Greenpoint, Williamsburg, a little bit of Fort Greene and Clinton Hill, and I'm really excited to be here this evening. Thanks to everyone who's tuning in and for the candidates for joining us. And I'll kick it over to my co-leader, Emil Bazil.
Hi, everyone. My name is Emil Bazil, and I am the second district leader for Assembly District 50. And I just want to thank everyone for joining us today at our Supreme Court Judicial Candidate Forum. It's a really great way to, help bring more awareness, raise more awareness to, the judicial branch and judicial system in New York State. I apologize. And I will pass it on to our district leader in AD 52, Jesse.
Thanks, Emil. Hi, everyone. Pleasure to be with you all this evening. I am Jesse Pierce, pronouns they, she, district leader in the 52nd and neighborhoods, Boerum Hill, Cobble Hill, Carroll Gardens, Brooklyn Heights, Gowanus, Park Slope, Prospect Heights. And yeah, we're super excited to be doing this. Thank you all for joining us and excited to speak with our judicial candidates. I'm gonna pop it over to Shaquana.
Hi, everyone. Shaquana Boykin. I'm here, AD 57. That's representing Crown Heights, parts of Crown Heights, parts of Bed-Stuy, Fort Greene, Clinton Hill, and Prospect Heights. We're really excited to be here. We all ran on that platform of transparency, and that's what you want, so you got it. So please stay tuned and hear from some of our Supreme Court candidates that are running. And I'll pass it to Sammy.
Thank you, Shaquana. Sorry, I have a cold, but I am Sammy Nemir Olivares, this male district leader from Assembly District 53rd. And like my colleagues, we think it's very important that there is judicial reform and that we get to know the qualifications, the professional qualifications of anyone who is aspiring to be judge. So we want an opportunity to hear from all of the judges in a non-biased, fair way, the same amount of time, and really delve into their qualifications so we can get qualified, prepare judges into the Supreme Court, and making sure that the judicial convention and the process is as transparent and professional as possible. So thank you all for your work and coming here and trusting us. And we hope that this is a very eye-opening, a new process that we can model in Brooklyn for our judicial system. Thank you.
Great. So now for a little bit about why we're here this evening. Why are we holding this forum? What is this all about for folks who are tuning in? First of all, thank you to everyone who is watching and to all of our candidates again for being here. So we wanted to hold this forum because we wanted to offer judicial delegates and the general public an opportunity to hear from this year's candidates for Supreme Court in the state of New York. And we are holding this forum ahead of the Judicial Nominating Convention, which will be held later in the summer. So at this Judicial Nominating Convention, judicial delegates from assembly districts across Brooklyn will vote to nominate certain candidates who will then appear on voters' ballots in the general election in November. It was extremely important to all of us when we ran our campaigns to become district leaders during the time that we've been in office to make sure that we brought greater transparency and inclusion into all aspects of what happens in our judicial selection process. So this is really what we hope to be a step forward in ensuring that judicial delegates from assembly districts across Brooklyn and voters and the public will have an opportunity to hear from candidates who are putting themselves forward for nomination at the Judicial Convention this summer. So we really hope that you all enjoy and learn a little bit from the candidates and get some more information about the folks who will likely, some of the folks who will likely appear on your ballots in November.
Thank you, Christina. Oh, sorry.
You want to go through the format?
Sure. So I'm going to discuss the format of this evening. We're going to be rotating between 3 different candidates every 30 minutes. So it's going to be a fun-filled evening of hearing from candidates. Each candidate will have about 10 minutes, and in that 10 minutes, we'll do a 2-minute introduction. And afterwards, we'll ask some questions and move on to the next candidate. Since we're also streaming live on Facebook, if we see some questions, we may try to pull them in. But my multitasking after a 9-hour workday, bear with me and bear with us. And we encourage some of the leaders will be just asking questions randomly based on the conversation and from questionnaires. So thank you to the candidates who are joining us for this first session. We're really excited and appreciate your willingness to participate. And we'll first start with Judge Jill Epstein.
I'm just gonna hop in really quickly to let everyone know I'm gonna be keeping time because we have so many candidates and want to be respectful and also mindful of how much time we're taking up. So I'll be keeping 10 minutes, and we'll also give a 5-minute warning as well. So, and thank you and welcome to all the judges. Judge Epstein, the floor is yours.
Thank you, Judge Epstein. Can you hear us? Okay, we'll move, we'll circle back. We'll hear from Judge Lillian Wan.
Oh, wait, I think I got it now.
Oh, there we go.
Sorry. How are you?
No problem at all. Good, welcome, thank you.
Thank you for seeing us.
And you have 2 minutes for your opening introduction.
Okay, great. I'm Jill Epstein. I have been in private practice or in the courts since 1983. I started out in family court, where I ended up being supervising law secretary to Marjorie Fields, who was co-chair of the Governor's Commission on Domestic Violence at the time. I then went into private practice for 15 years. And then I went back to the courts as my son got older and needed more of my time. And I was a law clerk from 2005 through to the end of 2018 when I became a judge. And I worked for Johnny Baines in Supreme Court and Civil Court for 9 years before I became a judge. I've been on the bench for 2 years in Civil Court in Staten Island and in Brooklyn. And I love the opportunity I've been given. It's been an amazing journey. When I was in private practice, I litigated in pretty much every court in the state and in the federal system, and including a lot of family work, a lot of entertainment litigation, a lot of civil rights litigation, and it gave me a pretty good background for when I took the bench.
Thank you.
Thank
do
you.
we have any questions from leaders? Go ahead, Shaquana.
Hi, thank you so much for taking this time to talk to us. I think
Thank you.
Of course. I'm very new to this process of the Supreme Court candidates running. And I think my question to you would be, if what is your pitch? What is your spill to just people who want to know, like, what does Supreme Court judges do, right?
Okay, well, given the amount of time spent as a law clerk in Supreme Court, we did all kinds of cases. We did foreclosures, we did NYCHA cases. With my judge, I worked on the Litch case for 2 years, where we dealt with Long Island College Hospital and tried to keep it open as long as we could, and ultimately were able to get a settlement that included at least an emergency facility, despite all the politics that were involved around that hospital. We also got to do things like keep open a senior center and daycare center in Williamsburg. That litigation came before my judge. He had me conference most of his cases. I did his research. I would do drafts of his decisions. He actually spent a lot of time, quote unquote, training me for the bench, because I would sit next to him and he would say, I don't know if you knew Johnny Baines. He was a big dude. He was around for a lot of years, and he would lean over to me and he would go, when it's your time, this is what you need to do. When it's your time, that's what you need to do. And he would always say, it's always about the people. And so in working with him, what I learned to do was make sure that every decision I make, every case I hear, every argument ultimately goes to making life better for people. And, you know, that can go either way depending on who the litigants are. And I like to think I don't have any predisposition, but, you know, I think a lot of being on the bench, especially in Supreme Court, is making the world a better place. And that's what I try to do. And I always try to remember that for the people that come in front of me, whether it's going to be in Supreme Court with the bigger cases like I worked on with my judge, or with the smaller cases that I see in civil court, each of those cases is the most important case in the world to the litigants who are in front of you. And so in Supreme Court, I would just get to do that on a larger and, you know, grander scale, you know, dealing with the foreclosures and dealing with the NYCHA cases and dealing with the larger personal injury litigations, you know, whatever that may be and whatever I'm called upon to do and whatever I'm lucky enough to do. That's basically what Supreme Court is. And I think we have an obligation to make sure that everyone who comes in front of us is treated fairly and understands what's happening. So, you know, that's where, and the fact that I've spent so many years in system and litigating, where I litigated in the federal system, in the state system, all the way up to the Supreme Court. And, you know, that I think that makes me unusually qualified for the seat that I would love to have the opportunity to take and, you know, to be given and for that opportunity. So that's essentially my spiel, as you asked. So I don't know if you have any more questions about that.
Sure.
No.
We have I'm sorry, Shaquana. We have another question from Leader Pierce.
Sure.
Hi, Judge. Thank you so much, Julia. I do want to give a quick time check. We have about 4 minutes.
Okay,
but
thank you, Leader Pierce.
Yeah. So I'll say that none of us as district leaders are lawyers, but one thing that I've heard from a few people is that judges, one way that kind of sets someone apart is their ability to display empathy and compassion within the courtroom. And so I'm hoping you could maybe share a specific scenario where you had to display empathy and compassion within your courtroom and provide specific details about why you felt it was important in that moment, just to kind of help us understand your thinking and your
Sure,
approach.
sure. Thank you. I had a case not long ago. It was a commercial landlord tenant case. And the woman who was the respondent owed a great deal of money. She had had some health issues and her business fell apart, and she was so far in debt. And, you know, my background isn't totally without dark spots. And I understood what happened to her. And I tried to speak with her and her lawyer and the other side. And ultimately, she decided to take a resolution where she didn't have to pay any of the back money and was able to give back the property, which allowed her to start a new life and to start over. And whatever business she wanted to restart up, she could do that with a clean slate. And in terms of empathy, her attorney actually came over to me at the end and thanked me for the compassion I had shown her, because I truly saw that she was in trouble and she really couldn't afford to pay back what she owed. So I think in trying to put myself in her shoes, I was able to get her a deal that let her go on with her life. So I think that's a moment in time.
Thank you.
Thank you.
Thank you. And what's our time check, Jesse? I don't think I heard you.
Oh, sorry, a minute left.
Okay.
Oh, okay.
Thank you.
I guess I had a question.
Sure.
If it's, I'm trying to make it a rapid fire, very quick. If one of your question in the questionnaire was about training, if, and I'm not too sure like the like what Supreme Court judges can and can't do while they're serving, but if you had the ability to provide some of those trainings, either the one that you suggested or one that you feel like you particularly have a strength in, would you be willing and open in doing it?
I would absolutely be if I had the permission of my supervising judge, which I would require to do it. And I think I would also need it from the administrative judge, but if I was permitted to, absolutely. I enjoy bringing people along so they understand what they're facing. I'm always uncomfortable if I see people come into a case and they're alone and they're pro se and they don't understand what's happening necessarily. You know, to us, it's like, oh yeah, it's another day. But to somebody who's never been in a courtroom, it's daunting. So I try to make sure that they understand, and to do that on a larger scale, I'd be really proud.
Thank you so much.
Thank
and
you.
that is time. And thank you so much for participating.
Thank you for having me.
Judge Lillian Wan.
Hi, good evening. Can you all hear me?
Yes, we can.
Yes.
Okay, great. Thank you for inviting me to this forum this evening. Hello to all the district leaders and my colleagues. It's good to see you. I am Judge Lillian Wan, and I'm the daughter of Chinese immigrants born in Queens. I've been living in Brooklyn for the last 21 years with my husband and my 13 and my 16-year-old. And I have been a judge for 9 years now. I am currently an acting Supreme Court Justice in Brooklyn Supreme Court in the civil term, and I sit in a civil trial part. And before that, I sat in Manhattan Supreme Court for about 1.5 years, doing a hybrid special guardianship and landlord-tenant part. And before that, I sat in the family court for 6 years in the Bronx and then in Brooklyn. hearing child abuse and neglect cases, juvenile delinquency, custody visitation, all those types of cases. And before taking the bench, I was an attorney at the Administration for Children's Services for 9 years. And I was also a court attorney referee in the Brooklyn Surrogates Court for 3 years. So I was doing the probate matters and administration and guardianship work in the Surrogates Court. I will also say that Brooklyn has never had an elected Asian American judge. And I personally think that it is important for the elected bench to reflect the entire community of Brooklyn. And I think that the population in Brooklyn is over 11.5% Asian American. So I do think that that is important. I am seeking your support, and I really thank you for this opportunity, and I'm happy to answer any questions.
Thank you so much. Do we have any questions, leaders? Christina? Leader Christina Platarski, go ahead.
Hi, Judge Juan. Thank you so much for joining this evening.
Hi there.
Hi. So I had a question about something that you said on your questionnaire.
Please.
And so in the question that was about, sorry, let me find it here. The judicial your philosophy on judicial activism. You said that you want to ensure that that people have the opportunity to have a full and fair opportunity to be heard, regardless of the ultimate decision. So I'm just wondering, is there anything in particular that you make sure to do when you're presiding over the courtroom to make sure that people feel like they have the full and fair opportunity to be heard? Is there anything that you would say that you do specifically to make sure that this is the case?
Sure. The example that comes to mind is when there is a court user or litigant in the courtroom that needs an interpreter. So I want to make sure that the playing field is level, and I want to make sure that if we have an interpreter, that the court user is able to understand the interpreter, make sure that we have the right dialect, to make sure that they are able to communicate. And that's even more important now in our virtual world where we have technical difficulties, and I have to check in to make sure that the interpreter and the person using the interpreter can really understand what's going on in the proceeding, and just to make sure that the proceeding is slowed down, to make sure that the interpreter is able to interpret the full question before an attorney raises an objection or something like that. So making sure that that person can fully understand everything that is happening in the court proceeding from beginning to end, whether it's me speaking, their attorney speaking, a witness speaking. So I think that would be an example of making sure that someone leaves my courtroom feeling like they've had a full opportunity to be heard. Thank you.
Thank you.
Sorry, I was searching for the unmute button. Any other questions from leaders? Go ahead, Leader Bazile.
Hi, Judge. So this question is from actually Facebook, and I'll throw it. It's from Aruna, and she wanted to know if you've ever been conflicted upholding a law or policy that you didn't agree with, and if so, how did you deal with it?
That is a great question. So, as judges, we interpret the law, we apply the law to the facts, but there have certainly been situations where, especially in family court, I can remember a particular situation where I felt that I was constrained by the law in terms of the options I had for a particular youth who was before me on a juvenile delinquency case. So obviously I have to apply the law, but I am a judge, and I can write a decision, and I can issue an opinion stating that, based on the law, based on the facts as applied to the law, the outcome needs to be this. But I have said, I am constrained by the law to rule this way. But in the situation that I'm thinking of involving the juvenile delinquency proceeding, I had a child who I wanted to make sure that outpatient services were available to the child, and the law was restrictive in that I only had inpatient options and institutional options for the child. So, in my decision, I applied the law, but I also said that, the parallel criminal procedure statute gave the judge more discretion with regards to community service options for this particular child to service all this child's needs holistically. So, I published the decision, and the Family Court Rules and Advisory Committee eventually they prepared a bill for the legislature, and the law was eventually amended to give the court more discretion with regards to juvenile delinquency cases involving children who had cognitive limitations and developmental disabilities, and treatment options for those children. So.
Wonderful, thank you.
Thank you for the question.
Thank you. Any other questions? Leader Boykin, I thought I saw your hand up.
Yes, I just had hi, so good to see you. I had a question around, I heard in the beginning, I heard you talk about language access, and yes. I'm all for language access, but I want to understand, in your view, is there any clear steps or any clear roles that you see yourself helping us get to more language access in the court system?
That's a great question. Sure, I do think, I'll go back to my family court experience for 6 years. With regards to the availability of interpreters, there would be times where a proceeding would have to be delayed because we didn't have that particular interpreter available. And in family court proceedings, every day is important and affects a family's life drastically. So, having to adjourn a case because a certain interpreter is not available is really a difficult thing. So, getting more interpreters, having more individuals take the test so they can become certified interpreters in the court system, having more interpreters, staff interpreters available in courts where interpreters are most often needed. I'm understanding that also in housing court that there's often a shortage of court interpreters, right? So having those interpreters in the courthouse when we all fully go back in person is, I think, is really key. And the family court, the housing court, they're traditionally under-resourced. And I think just having a greater pool of interpreters would really help and would assist with moving cases forward faster.
Thank you so much. And I believe that is time. Thank you so much, Judge Juan, for participating.
Thanks for having me.
And now we'd like to hear from Judge Connie Malafre Melendez. Did I pronounce that correctly?
You did. Excellent. Thank you. Thank you. Good evening, everyone. And I too thank you all for this forum and the opportunity to listen to us and hear what we have to say, and just being here. So I was elected in 2017. I had a very contentious election, and I'm really very, very proud of having had such a big victory. It was a countywide race, And I was the candidate with the most votes. And that was a big deal because Brooklyn is humongous. So since my election, I was first assigned to criminal court, and I served in criminal court for a year. It was a fabulous experience. I thought that it was gratifying. I was doing for the people and being fair, and honestly, both sides of the bar, the lawyers for the plaintiffs, for the district attorney, and lawyers for the defendants, the people, respected me, and just all around, it was a great experience, great job. My experience lies in civil matters. And so from 2019 onward, I was reassigned to civil court, and that's where I preside. And there we listen to all sorts of cases stemming from small claims to no fault to commercial landlord-tenant consumer debt. It is the people's court. And in that respect, it is very gratifying. And your questions talked about pro ses. We deal with a lot of pro ses on a daily basis. But back to who I am and what I'm about. Prior to becoming a judge, I worked for a Supreme Court judge. She was a judge assigned to medical malpractice. I worked for her for 10 years, and I was her right-hand person. And the job suited me really well because prior to that, I was a medical malpractice litigator. I defended the doctors and city hospitals in medical malpractice cases. And I did everything from the beginning of the case to trials of the cases. Prior to that, I was a social worker, and I dealt with families and children, mostly moms who were victims of domestic violence, and children who also suffered from those situations, and they needed very specific and personalized intervention. And in working with these families, I went to court and I advocated for the children as a social worker. And that led me to want to be in the legal field as an attorney. And I went to law school. I went to Brooklyn Law School, and I got my degree. I'm going to tell you that I am an immigrant. I was born in Cuba. I came to this country as a young child. In those days, this goes back a lot of years. In where I lived, there weren't a lot of Latinos or other diverse groups, other minorities. And so it was a tough time. We spoke differently, we looked differently, we didn't have the same customs and ideas. And I tell you this because this is part of who I am and part of what I bring to the court as a judge, because I see everyone as equal and I understand what people have to go through to get to the legal system and to get before a judge and in court. And, it's something that just is a part of me and is something I bring to the court. And hopefully going to Supreme Court, I can continue the work and continue to be of service to the public in a greater forum, in a larger forum with more risks at stake. I'm married, I've got 3 grown kids. I seek your support. And again, I thank you.
Thank you, Judge Melendez. We have a question from Leader Pierce.
Hey, Judge, thank you so much for being here with us. I want to draw upon something you mentioned in your survey. You talked about one of the greatest obstacles to justice being economic disadvantage and also racial and cultural differences, and kind of also mentioned the need for more implicit bias training. I'm wondering if you could give maybe a specific example of a case or an experience that you feel and share the details that you feel like really drives this point home for you.
Yeah, I'll tell you, when I was in Supreme Court as a court attorney, I witnessed the implicit bias in a number of different situations. One situation involved a Latino plaintiff, and she was on the stand, and she was really hysterical. She was very, very distraught, very upset. And I saw that her emotional being, her emotional status was being perceived as drama. When the judge, I was, with the judge, we took the lawyers out for a sidebar conversation outside the jury. And, the lawyer was really harping on the plaintiff, on the witness, on the stand with, her drama and her tears. And the jury is listening to this, and the judge took it into her hands to control the situation and to, basically direct him to stop with that tactic. And, I can't remember the outcome of the case. I don't remember if the plaintiff won or lost or whatever, but I could see the jury just kind of, thinking, oh, Latinos, they're drama queens, kings, etc. On a different situation, it was an LGBTQ litigant, and we had conferenced the case. We were about to start the trial, and the litigants were both there, both sides. And when they left, I saw court personnel smirking and giggling, and it was absolutely disgusting. As a court attorney, I can't do much. I couldn't do much, but as a judge, I can. And so those are the types of situations that occur. And, are they doing it on purpose? Is it that implicit bias where people just think of stereotypes and assume that a person is either lying or exaggerating or what have you based on those stereotypes? As a judge, I can control that. And I seek to do that, and I do it every day in my courtroom, and I seek to continue to do that in Supreme Court, again, where the stakes are even greater.
Thank you so much. Just a time check, there's about a minute 45 left.
Thank you. And Jesse stole my question about implicit bias, but I appreciate that. Do we have any other questions from leaders? Go ahead, Leader Boykin.
I just had a two-part question. One is, how many times, if any, have you ran for this position? And the second one is, if you ran before, what is it that you have learned to do differently this time?
Yes, I ran twice. I ran in 2016 in a countywide race against one individual. So it was a much smaller race. And then in 2017 against 10 other people. The second experience was, we fall and we stumble and we fail. The first experience was a failure, but I seek to learn from my failures. And I didn't really learn about what I did wrong because I did everything right. I maybe should have done more of everything that I was doing right, meaning I should have, had I known, I would have tried to reach more people. And so the second time around, I reached more people. And as I did so, I got to learn so much about the Brooklyn public and the Brooklyn communities and just all the people that I was to be of service for. So it would have been so much nicer and easier had I just won in 2016, but I learned so much, and it's part of life, and it was my learning experience, and it was great, and it's been great so far. And so I missed a year, big deal. It's still good.
Thank you.
Thank you, Judge Melendez, and that is time. We appreciate you folks joining us for this first session. We're going to rotate now to our next round of judges. And you can view it on, we're streaming on Facebook Live, and I can share that in the chat.
Thank you. Thank you, everyone.
Thank you so much for your time.
Thank you for seeing us.
Thank you for being here.
Good
Hello
evening.
and welcome.
Thank
Good
you.
evening.
Welcome.
Thank you for your patience. And I believe I am turning it over to my colleague. There you go. Shaquana.
Hi. Thank you so much, Julio. Shaquana here. I am looking forward to introducing our next set of candidates. And let me, Joanne, are you up first?
Am I?
Are you ready? Are you ready?
I guess as ready as I'm going to be.
All right. Well, who do we have? Yeah, so we have our all three is here. So we have Joanne, we have Richard, and we have Judge Dina. Thank you so much for your time. You know, please take your time. There's no wrong questions. We just want to get to know you and really open up this closed space to everyone. So Joanne, can you go first?
Okay.
Hi, I'm sorry to interrupt. I'm just going to be the timekeeper, so I'm going to keep us on 10 minutes, and then just look in the chat, because I'm going to try to do like a 5-minute warning for everyone, just as housekeeping. Thanks so much.
Okay. Thank you. So good evening, everyone, and thank you for coordinating this forum and for giving me the opportunity to participate and to share a little bit, well, hopefully a lot, about me and my qualifications. I want to thank my district leader, Shaquana Boykin, which is how I found out about this event. So again, my name is Joanne Quinones. I grew up in Bushwick, Brooklyn, and that was before it became the hip in place to live that it is now. Much like my old neighborhood, I developed over time into the person that I am today. So it's with great humility that I share my story about how I went from Bushwick to the bench. Growing up, I did well academically and was accepted into Prep for Prep, which is an educational and leadership development program for students of color. Because of Prep for Prep, I was afforded many educational opportunities. I went to middle school at Chapin. I went to high school at Phillips Academy. I went to college at Brown. And then I went to Fordham Law School, which is where my legal journey began. As my world expanded beyond Bushwick, I began to see disparities in the way that people lived. You know, in the availability of and access to resources, and it fueled in me a desire to pursue a career in public service. So since then, I've had a varied career as a public servant. I've been a public defender, I've been a court attorney, a small claims arbitrator, a criminal court judge, and since 2017, I've served as an acting Supreme Court justice on the criminal term, handling felony matters, including jury trials. I also volunteered to assist in the backlog in family proceedings that resulted from the pandemic. So I am now also handling matrimonial and custody issues on the civil side of Supreme Court. I have extensive community and bar association experience, including as a past president of the Latino Judges Association and the Brooklyn Women's Bar Association. And through my involvement in those organizations, as well as several others, I have shown my longstanding commitment to promoting racial and gender fairness, diversity and inclusion, and access to justice. I present continuing legal education classes on implicit bias to bar associations and judicial associations. I mentor students of all ages, leaders of tomorrow, and I affectionately refer to them as Camp Quinones. I benefited from lots of mentors. And so now I'm trying to pay it forward by mentoring others. I come before you with 24 years of legal experience, all in the public sector. I am committed to serving the community and to restoring the public's trust and confidence in our system of justice. So it would be a great honor for me to serve the people of Kings County as a Supreme Court Justice, and I respectfully request your support. Thank you so much.
Thank you. Do we have any questions from leaders? Go ahead, Leader Brazil.
Hello, and thank you for a wonderful introduction. First question I would ask, this was from Facebook. I didn't get a chance to ask last time, but this is from Jessica Baker Vidor. And she asked, can you share the last book you read that helped you see the world in a different light?
Wow, that is a great question. The last book that I read, that showed me the world in a different light. I don't know if I want to go with Sonia Sotomayor's book or with Michelle Obama's book, because I think that they are both such strong stories about women and powerful women. I think that, you know, growing up, I didn't have a whole lot of confidence. I think it took me a while to kind of become a public speaker of sorts. And reading their stories, I think, showed me that, you know, I could be anybody I want to be. And here I am, a judge speaking in front of all of you. So I would go with one of their books.
Thank you.
Thank you.
Leader Napotarski.
Hi, Judge Quinones. Thank you so much for being here and for sharing your story with us. So I had a question based on your questionnaire. And so in your questionnaire, you spoke about encouraging those involved in the justice system, including yourself, to challenge disparities. And I'm just wondering if you have a few examples of how you've done this in the past from the bench, and how you intend to do this moving forward.
Well, I think that the last year has definitely shown us not only, I mean, I think we were all aware, right, that systemic bias and implicit biases are prevalent in the court system, but we weren't aware to the extent that they are. And I kept asking myself, like, what can I do? What more can I do? So what I started doing was, whenever people asked me to present a continuing legal education course, I decided that I would do it on implicit bias, because I think that the more we become aware of our implicit biases, the more we can work to rectify them, right? Because studies show that if you become aware of your implicit biases, you are highly motivated to correct them because you don't want to get called out on your implicit biases. With respect to the bench, I will share a story that way back when I was handling DATs, desk appearance tickets, and everyone was coming up before me, and everyone was getting a marijuana ACD, which you're entitled to. Well, now the laws have changed, but back then you were entitled to one marijuana ACD in your lifetime, and it was open for up to a year, but with the prosecutor's permission, it could be sealed earlier. So there were like all these like Wall Street type, you know, people coming before me, and the prosecutor was like, marijuana ACD with immediate sealing, marijuana ACD with immediate sealing. And then there was this like young man of color who came before me, and the prosecutor said, marijuana ACD. And I said, with immediate sealing, right? Because that's the standard offer today. So, you know, those are examples of how I would kind of challenge disparities on the bench and off the bench.
Thank you.
Thank you.
Thank you. Do we have any other questions from leaders? Go ahead, Leader Pierce.
Thank you.
Thank you,
Judge, for being with us.
My
My question is,
you know, I see from your questionnaire that you
you started as a public defender. And I'm just kind of wondering, through the course and the journey of your career, if there was any particular struggle or situation that you think was very formative for you in your experience in the court, and if you don't mind sharing some of the details with us.
Do you mean as a public defender or just throughout my career?
Sorry, I'm just referencing it as like kind of the spectrum of your career. But I think anything that you think is meaningful to you that you don't mind sharing that influenced you in your legal career, either as a public defender or as a judge.
You know, I think that I always held to the value of making sure that people's constitutional rights were protected. And I would often speak in front of groups, you know, student groups, or even with my friends. And when I decided to become a public defender, they would always ask me like, why? How could you defend somebody who's, you know, a criminal? I said, first of all, everyone is innocent until proven guilty. And how could I not use my legal skills and my oral advocacy skills that I developed throughout, you know, my career to safeguard people's constitutional rights? So it became very important to me to kind of like engage in this like educating of other people about constitutional rights, and that everyone is presumed innocent, and that people deserve a trial by a jury of their peers. And I think we look around at these juries. I mean, Brooklyn is very, very diverse, right? So we can tend to find some diverse juries in Brooklyn, but in other places, we are not getting diverse juries. So how are we summoning our jurors? How are we treating people who come to the courthouse to serve as jurors that we are losing so many diverse jurors? So, you know, educating people, that is how I think, you know, seeing the stark kind of issues that appeared, right? Like all these non-diverse juries, and going out into the community saying, we have a civic obligation to be part of the system. If you think there's a problem with the system, you got to be involved. So I'm not sure if that answered your question, but, you know, I can provide more of an answer if you need more. Thank you.
Thank you. And I believe that is time. Thank you so much, Judge Quinones.
Thank you.
Thank you.
Thank you.
Julio, I do not have my screen up and I'm doing a bad job. Is Miss Dina next?
I'm here. I'll be happy to
Yes.
do that.
Yay. Thank you, Ms. Dina. Please give us an opening about you, and then we'll ask you some questions.
Very well. Good evening and thank you. I'd like to first express my sincere appreciation to the district leaders for giving me the opportunity to appear before you, and good evening to my colleagues. My name is Dina E. Douglas. I've been a judge for 15 years and an acting Supreme Court justice for the last 6 years. I appear before you as a candidate to be elevated to the Supreme Court, the same court to which I've sat for the past 6 years. I was born and raised here in Brooklyn after my family immigrated from the Caribbean island of Carriacou, Grenada, West Indies. I am a highly respected justice serving most of my legal career in Brooklyn. A graduate of St. John's University School of Law and completed my undergraduate studies at Northwestern University. I was elected to the Civil Court in 2006 countywide by an overwhelming majority. And in 2016, I was reelected to my second term where I was unopposed. The Chief Judge elevated me to serve as an acting Supreme Court justice, where I am currently assigned to a jury trial part and preside over major felony matters, including homicides and complex gang crimes. I too took the call and volunteered to family court due to the backlog that would developed under the COVID pandemic. In family court, I manage custody and visitation cases. Before my election in 2007, I served as an assistant district attorney here in Brooklyn for 12 years and fairly prosecuted dozens of high-profile homicides and major offenses. I was a deputy bureau chief of the Domestic Violence and Homicide Bureaus and chief of Trial Bureau 1. I was then recruited by the United States Department of Justice, where I prosecuted complex federal, domestic, and international terrorism matters. Early in my career, I was a regular commentator on Court TV, and taught legal reasoning at Brooklyn College. I believe in giving back to the community and inspiring others. I served as the Mistress of Ceremonies in last month's Caribbean Heritage Month celebration in the courts. I participate in numerous Meet the Judges panels and college and high school career days. I cheerfully take on summer mentors, high school, college, and law students every summer. And I serve as a member of the Caribbean American Lawyers Association, the Brooklyn Women Bar Association, and the Brooklyn Bar Association. In addition to my community work, I was selected as the first justice to preside over both Project Safe Surrender and Begin Again, which are community court resolution programs. I serve on the board of directors of the Judicial Friends Organization, which is committed to racial equality in the law. I serve on the executive board of the Nathan R. Sobel Inn of Courts and chair the Kings County Criminal Court Gender Fairness Committee. Tragedy struck my life when I became a widow after my husband received a sudden, unexpected, aggressive cancer diagnosis. I am the mother of two, and simply put, they are the apple of my eye. I continue to look for new and creative and innovative ways to affect change and develop innovative programs in criminal justice. I'd like to thank you again for giving the opportunity to appear before you this evening, and I welcome any questions you may have.
Thank you, Judge Douglas. Do we have any questions from leaders? I have a question. I was looking at your questionnaire, and you touched on something that all of us district leaders here is really we really value, like transparency. And you said it was a question, and you said something about like you really believe that we should take not only the charge that the person has or like what the situation is, but take an account of like the community and the environment. Can you speak more to how you, I know you have the power to do certain things, but like your discretion?
It's interesting. And as I've described, my whole experience is in criminal law and criminal justice. And the sentencing guidelines is a place of great judicial discretion. And there are opportunities for me to review the background of someone who is accused when the defense counsel will submit a pre-pleading memorandum. It's something that's directed to the district attorney, but that the court, I as the judge, always ask for a copy of it so that I too can learn about the extent of one's background and experience, because I know that someone may have challenges that may not be readily identifiable to the naked eye. One of my children, my son, has a neurodiverse brain. He is a college student and is doing extremely well at Morehouse College, but I understand the challenges of what may be misunderstood by some in helping another to develop into a full person. So I bring that passion from my own life experience to delve deeper into what somebody else's life experience may be. So in that pre-pleading memorandum that I described, there may be something, and you continuing with the example of someone with a neurodiverse brain, who rather than a criminal conviction or incarceration could use some other services that could help them to develop and to go further in their life.
Thank you. We have a question from Leader Bazile.
Hi, Judge Douglas. Thank you for being here tonight. So this is a question from Yomi on Facebook. And Yomi asked if you can elaborate on the innovative programs that you've developed.
A part of it, it sort of dovetails on what I was just speaking about in terms of the sentencing. There are a number of the district attorney's office is the office that generally will have control over some of the innovative programs that are available. But I always welcome the defense bar to also come forward with whatever programs may be available. Because there's no one size fits all solution to the various issues that may occur in criminal justice. So I often look to see, are there alternative resolutions as a way to resolve the case? And that does require an innovative eye. One may not necessarily think that a program which may, there was a program that came up in a case today where it included 200 hours of teaching. And that was a welcome opportunity to be able to assist in the negotiation to see, is that going to be a fair resolution to a case? Now, one may not think that a teaching opportunity may be connected with someone who is accused of a crime, but again, you have to look deeper, understand the background and experience, and see, is there a way that a resolution can be reached that would be fair for all accused and involved.
Thank you.
Welcome.
Do we have any more questions?
Yes, another question from Facebook.
We have 1 minute. Go ahead, Emil.
From Aruna, and Aruna asked, what are some ways you would like to see the criminal justice system change?
You know, it's interesting because, of course, as a judge, our hands are somewhat tied in that we can't speak to policy. And I see you shaking your head, Emil. But I can answer the question, but I do want to make sure that the audience understands what the parameters are of what a judge can and cannot take or say. And when we look at the bail reform, it has been a progression in criminal law and criminal justice that has been welcome by many. Some have been concerned over some of the changes in the bail reform, but as we've seen that as it has been in effect now for almost 2 years, it has provided for some a tremendous opportunity for alternatives rather than, again, what the same thing that I come back to is incarceration. I mean, we'll be careful to also address that if someone is accused of a heinous and violent crime, and the purpose of bail is to assure one's return to court, then the parameters of what bail should be set and are considered are naturally very different in a case like that. But, you know, even if we go back to some of the minor matters, being in a park in the dark, after dark, somebody is accused of a minor offense, having the ability under the bail reform to understand that incarceration for those offenses is not necessarily in the best interest of society has been a welcome change.
Thank you.
You're very welcome.
Thank you. Do we have any more? I believe we ran out of time. So sorry. But we have up next, Richard, are you ready? All right. So the floor is yours. Please tell us about you, and then we'll have some questions.
Yes, thank you, Shaquana. It's great to see you again. And I haven't met Julio or Emil or Jesse yet, but I do look forward to eventually meeting you as well. I want to acknowledge my colleagues who I adore, Judge Quinones and Judge Douglas. I also want to acknowledge my husband, who's also listening as well. In the brief time that I have, I know it is not possible to condense 37 years of legal experience in a few minutes. Instead, I will share with you the lens in which I see the world. I see the world through the eyes of a former VISTA volunteer who saw poverty up close and personal, who went to law school and then became a legal services attorney and then a legal aid lawyer. I cared about my clients, whether it involved protecting the elderly or working with parolees for alternatives to incarceration. When I went into private practice, I still didn't stop caring. I was a proud member of the board of directors of the South Brooklyn Legal Services. I think it's the best legal services office in the country. And I was co-chair for I was on the board for 9 years, co-chair for about 6 of those years. I also see the world through the lens of a member of the LGBTQ+ community, who for years was denied the basic dignity of being able to live without fear and to marry. I saw the injustice of the highest court in the state of New York tell me that my relationship was not equal to other relationships. I will tell you what you already know. It makes a difference who sits at the table, and it makes a difference who sits on the bench. I see the world through the lens of a judge. I know the burdens of the office and its limitations. I know the earth-shaking effect that judicial decisions have on people's lives. I spent a little over 2 years in criminal court, and during that time, I arraigned more than 25,000 individuals. Whether someone was released on bail or on their own recognizance may very well determine whether children are cared for or lost to foster care, or a job is kept, or homelessness ensues. These are only some of the lenses through which I see the world, and they inform my judicial decisions and philosophy every day. Thank you for giving me this opportunity, for your consideration. And if you have any questions, I'm more than happy to try to answer them.
Thank you. Do we have any questions from leaders?
Yes. I'd like to ask you a question. Had there ever been a case where you wake up in the middle of the night about a case and you wish that you had handled it differently? And if so, if you could just please describe one situation.
Most cases that I determine, it always depends on the court that I'm in. The one that creates more sleeplessness for me, other than criminal court in the arraignment part, because that if you make a decision that turns out that the person who you release on bail or on their own recognizance commits a crime, you wind up on the front page of a newspaper. To tell you the truth, I haven't lost very much sleep over that because I'm just doing my job. The cases that I think address your question are more in the mental hygiene part of the court. When I'm making a decision as to whether somebody lacks capacity, sometimes it's a determination as to whether or not that person has to be forced to take certain medication that will have really awful side effects. But that medication can be a lifesaver in that the person could actually function in the community. And without it, they cannot function. So I've got to make a determination. Does that person lack capacity? And you can hear from the psychiatrist, you can hear from they call it an alleged incapacitated person. That's what the court describes the individual at. Those are tough decisions. Those I lose sleep on. Did I do the right thing?
Thank you.
You're welcome.
Any other questions? Leader Pierce?
Hopefully my audio is better.
I can't hear you, but if you write the question, I will try to answer it. Oh, I'm so sorry. I'll do the best I can.
We'll wait a few moments Jesse types their question. Oh, pass. Sorry, folks. Okay. Is there any other questions?
I forgot to raise my hand, but I do have a question. So hi, Judge Monteleone. Thanks so much for being here with us this evening. I had a question about something that you said on your questionnaire. And that is that you said there are instances when the law or the application of the law falls short. Is there any one particular place right now? I know you spoke about bail reform and how that's been changed, but is there one outstanding particular place where you think the law is currently falling short, either in how it's written or in its application?
Absolutely. The one that comes to mind the fastest is the commercial part of the landlord-tenant court. I deal with it, some aspects of it in Supreme Court, because actions are brought in that court as well on different statutory grounds, usually as part of a foreclosure. In a residential setting, if a landlord wins a case and they have a lease that says that the landlord is entitled to attorney's fees, then the law implies reciprocity. In other words, if the tenant should win, the tenant can be awarded attorney's fees. In the commercial part of the court, there's this false equivalency, where if the lease says that the landlord is entitled to attorney's fees if they win, the same reciprocal right does not go to the tenant. So a landlord could spend $100,000 on litigation, lose, bring a case that really didn't have much of a legal basis, and the tenant doesn't have that same reciprocal right. And in the commercial part, which is very similar to the residential part, 90% of the tenants are not represented, and 90% of the landlords are represented. So you have an injustice just because the law doesn't imply reciprocity, and there's not a statute that does it either. So the law falls short of doing justice.
Thank you.
You're welcome.
Thank you. And I think that brings us one more question. Jesse's question was around training around technology for the courts. If you had a specific need in mind regarding technology.
You know, I don't have something specific in mind. I know everything from projectors to point and click. What I really need is somebody with a technological background who could tell me everything that a modern courtroom is capable of. I know it's more capable. I mean, we should have computers in there that can be used, that can project things onto the screen. We should, in the future going forward, have some way of remotely taking deposition testimonies or witness testimony during the course of a trial. Recently, I did a trial where it was partially in person and partially virtually. One of the witnesses was in Canada and they couldn't come down to the United States because of the COVID situation. Why can't we permanently set up something like that in the courtroom so that in the future we could prevent some unnecessary expenses? And you know, in those instances, I think it's important that you get the consent of all the parties. But there will be occasions where you can get the consent. There will be occasions where you want to see that witness in court. But for many cases, I think you could do that. I'm just thinking these out of my head. But I know I'm not a technological genius. I know that they exist. They should be talking to the judges. What do you need? This is what's out there. Why not have why not have laser pointers to be used if somebody's using something illustrative? I wish I could answer that question better, but I wish I had the technological background to better, outfit these courtrooms. They're almost like oil lamps to light the courtrooms. I mean, we're sort of in the Stone Age.
As an educator, I can sadly relate. Thank you, Judge Monteleone, and thank you, candidates. We're fortunately at time. I will be dropping the link to the event if you'd like to continue watching on Facebook, and we're going to be moving to our next candidates.
Thank you. Good night, everyone.
Thank you all. Good night.
Good night.
Thank you. Good night.
Thank you very much. Bye-bye. Good night.
I believe this judge's judge, Adam, there we go. Judge Perlmutter. Just want to make sure that was you.
Hello, everybody.
Hello.
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 And I'm turning it over to my district leader colleague to start us off.
Great. Thank you, everyone, for joining. Really appreciate you coming and sharing a bit of your story as why you want to run for Supreme Court. So we will start with Judge Ann Swearn. Please, a 2-minute introduction, and we'll open up to questions.
Thank you so much for doing this. I can't begin to tell you how wonderful that you district leaders have decided to do this. I wish all the district leaders did that. And I come from a place of experience because I was a district leader for very brief moments in my life. And it is amazing that you've organized this. And I know that my colleagues are extremely grateful that you've done that. Thank you to my particular district leader, Jesse Pierce, and thank you all of you. My name is Ann Swearn. I've answered your questionnaire. So I will just highlight some of the things that I said in the questionnaire, which is I have a very unusual background. First of all, I've served the public for over 40 years continuously, from the moment I left law school till now. I was a prosecutor for 33 years. And what was highly unusual, unprecedented really, was that I was the first assistant DA in Brooklyn. I had served 4 different DAs in Brooklyn. And then I was given the opportunity, the amazing opportunity, to be managing counsel at the public defender's office. And as much as I thought I knew about that work, having been their adversary for 33 years and being in the courtroom almost every day of my career, it was nothing like being among them and sitting among them with the colleagues and with their clients and with the issues that they faced, which opened my eyes in a tremendous way. I've taught law school for 20 years. And I think what I bring to that law school, I created the course. It's called Problem Solving Justice. And what I brought to the course before I worked at the public defender's office and after was immeasurably different, because it exposed me to the way public defenders see the world, the way their clients see the world, which then brings to my judging another level of empathy, another level of humility. But for the grace of God, go I. I could be that defendant. I could be that lawyer. I could be that advocate. How would I want to be treated if I was in the well of that court? And so for my experience, I've been really, really lucky. I've gotten a lot of opportunities to do a lot of great things. And so I was given the opportunity to be on something that's extremely prestigious, which is the National Criminal Justice Council of the American Bar Association. People like me don't get to get that job. And the reason I got the job, I was a chair of the reentry committee, I was a chair of the diversion committee, but then they made me a special advisor. And the reason I'm a special advisor is because I have the 4 qualifications that some people only have 1 of. I was a prosecutor, I was a public defender, I was a law school I am a law school professor, and I'm a judge. And those are the things in criminal justice that you bring to the table. And I pay it forward by being a resource to committees. And I'm, for example, right now I'm on something called the Diversion Task Force, setting the standards around the country, so that if you create a problem-solving court, or you create a problem-solving program and use the principles of alternative sentencing, what kind of guidelines should you employ to make it fair, to make it sensitive to community norms, to inclusion issues, diversity issues, and everything, so that it does what you ask questions about public consciousness and how do you serve the public. That's how you serve the public, by including the public in your decision making, whether you're thinking about it when you're making an individual's decision or when you're creating programs and procedures that have people included in your decision making, how you can effectuate the public good. And so I will just say this in terms of the 50th, the 51st, the 52nd, and the 57th Assembly District. I was elected by 57,000 people in those 4 districts to be the civil court judge that I am now. the way I got here was not the district leaders, it was county committee. Those are the county committees for the municipal district 1, which is where I sit, I'm elected to. And those county committee people are the constituents. And Jesse Pierce knows that I have a very strong desire to be collaborative in all the work that I do. That when Rep the Block first came about, I was a brand new district leader. The people from various progressive groups came and said, we want more people on county committee. We think it's grassroots. We think that they should be involved in all of this decision making. And so Jesse and I worked really hard to make sure that our county committee in the 52nd Assembly District was filled to the basically to the maximum amount of people we could find that could promote goodwill and promote public policy for the 52nd Assembly District.
Great. Well, thank you for that. And I guess I'll open up to questions from our leaders or anyone on Facebook that might have questions for Judge and Sworn. Okay, I'll open up from a question that was asked earlier, and I think it was a really great one. So it is: have you ever been conflicted upholding the law or policy that you didn't agree with? And if so, how you dealt with that?
You know, in criminal court, in the lower criminal court, there's a lot more discretion because there's not mandatory minimum sentences. So you can do a lot, you have a lot more flexibility and the ability to use your discretion. But it may not be a conflict, but I have a case that I'm dealing with right now where the person has done something pretty serious, several cases in criminal court. And I'm conflicted because how do you hold that person accountable for their behavior and keep the community safe? And holding them accountable might look like punishment. Keeping them safe might look like some kind of therapeutic approach. And how do you combine both of those things in order to effectuate justice? And the district attorney could say, well, we want the maximum amount of jail time, but I have the discretion to do what I want. And how to combine both of those principles so that the public is safe and also a person's held accountable. And I'll give you an example of when you have the experience of seeing 40 years of cases to do the right thing and when you're vindicated. I will tell you about that. The district attorney's office, I sit in Manhattan right now, and the district attorney's, their office didn't like that I was using my discretion in a particular way at arraignments where they were asking for orders of protection in every single case, no matter what the facts were. And I would listen to the facts and I would listen to the victim's story through the DA. I'd listen to the defendant's story through the defense attorney. And especially during COVID, it could make a person homeless to decide in that moment that that person should be put out of their home. So I was doing things called limited orders of protection under various circumstances where I thought it was right. And I got word that the DA's office didn't like that. Well, fast forward, the New York Times has now written 2 articles about when judges don't do that and why it denies people justice. And there was just an appellate decision that required a hearing to be done where hearings weren't done because of what I was doing. So when you know you're right as a judge and you buck the system or you buck the way things are done because the way that they're done, it really it empowers you to continue to use your heart and your head in meting out justice. And that's what I do every single day.
Thank you. And I will pass it to Leader Borton. Their hand raised.
Hi, thank you. I would have a 2-part question. One is I heard you speak about your time, but looking at your questionnaire, I see a lot of background in the criminal justice part. Could you speak to a situation or how you use discretion when it comes to your time in a criminal justice? And for me, I've always I love youth, young people. I feel like if we don't tap into young people, then they become adults that are not tapped into, and then we're looking around like, wow, this adult is not engaged, right? But it starts young. So when it comes to not only discussion, a lot of times I feel like people don't give people resources or alternatives. Is there times that you are able to give people alternative to jail time or just not being involved in the criminal justice system?
Jail should be the absolute last resort if you can't do anything else to hold a person accountable. And it almost never in criminal court is required, almost never, because there is usually an underlying reason that the person's there in the first place. For example, I was in the inception of the Red Hook Community Justice Center, for anybody who's been out there. And what happens is a person gets arrested. The police bring the person to the court. The person meets with a resource coordinator who says, are you in school? What's going on at home? You know, what's your living situation? Do you have a stable living situation? And gets to the root cause of why the person's there, so that the person may never see a judge or see a judge but never have a criminal conviction, never have the collateral consequences of a criminal conviction, and be able to take from a terrible experience of getting arrested a very productive future. That's the thing I try to do with almost every case that I see. And when I'm in criminal court, it's sort of like an emergency room doctor. I can be in the arraignment part one day. I can be in an all-purpose part the next day. I could be doing extraditions, which are the most serious cases because it's cases where around the country, the person's committed the most serious crime and the person gets arrested in New York, but has to go back to the place where they were arrested. And these are places that have completely different norms and laws than New York does. And how do you use your discretion when you're looking at a case that would not be even a crime here, or would be such a low-level crime that wouldn't get punished in the same way as if you're sending it to a state that punishes much more severely? I would set bail in that case, or I would release the person on their own recognizance to go back to that location. And I've done that. I had a guy once who got arrested. He was from Virginia or someplace. He was on a cruise and the cruise ship found a warrant on him. And it was such a silly case to me that he said to me, please, I'll go back to Virginia and then I'll come back to New York and show you what happened. And I released him. And the defense attorney wrote me a letter and said, no judge would have done that. They wouldn't have released the person because they were so worried that Virginia would get mad. I'm like, but this wouldn't happen in New York. I'm a New York judge. I have to do what I think is appropriate in New York based upon what my experience is and what my knowledge is. And it works out. I've had a number of letters and comments from people. When I was running for DA, people would come up to me on the street and say, you saved my life. You got me drug treatment, mental health treatment. Now, there are mentally ill people in the criminal justice system, as you know. They'll come before me in court, and it's stressful for everybody to be in court. It's very stressful if you suffer from mental illness. But there's a way to handle the courtroom that damps down that stress. And these are all the kinds of things that I do with my discretion to make my courtroom the fairest, most empathetic, most conscious of criminal justice and how it needs to be reformed in a way within my judicial discretion and within the law, because it does need to be reformed. But what can I do as a judge? I can make people feel comfortable in my courtroom, and I can give them options where hopefully they don't have a criminal record. And of course, they don't get sentenced to jail, but that's criminal court. That's the lower level court. There is mandatory sentencing in the upper level court. And that's why I spoke about in my questionnaire, being able to apply principles of alternative sentencing in the Supreme Court, where it's much more limited in terms of what the court system provides. But that doesn't mean we as judges can't do it.
Thank you.
Thank you, Judge and Sworn. That it's time, and we're going to pass it up to Judge Adam Perlmutter. So 2 minutes for an introduction and some questions.
Get myself unmuted. Hello, can everybody hear me all right? Good, excellent.
Yeah, you're good.
Thank you. Good evening to everybody, and thank you so much for having me. I wanted to take these 2 minutes to try to briefly frame our discussion tonight by telling you a little bit about my background, my view of the law and society, and my approach to judging. As far as my background is concerned, it's unique. We're all unique, but I think my background's a bit more unique than most. There are no other judges tonight, or frankly anywhere, who have the individual and collective experiences that my legal career has given me, especially as applies to Brooklyn and to the people of Brooklyn. That's included overturning wrongful murder convictions in Coney Island, stopping power plants and real estate developers in North Brooklyn, pioneering a new legal pathway to protect prisoners from sex abuse, and stopping the use of the death penalty against somebody from Brownsville. These experiences are my record, and I'll line them up against any judge to argue that they make me worthy for sitting in New York Supreme Court. My approach to these cases reflect my view of the law and society. And simply put, for me, the law is a tool that can and should always be used, in the parlance of the Dr. Martin Luther King Jr., to bend the arc of history towards justice. Lawyers and ultimately judges must always exercise that tool to bring about just results for the benefit of individual cases and parties, and for society more broadly. And I've tried to live my life as a lawyer and now as a judge dedicated to that proposition. And on the bench, that's meant using restorative justice techniques to reduce recidivism and drunk driving, advancing transparency and protecting the rights of immigrants in my courtroom, working to eliminate wrongful convictions and racial disparities as a member appointed by the chief judge of the state to the New York Justice Task Force. And as for my approach to judging, there's some seagulls here, so they may be, they're listening as well. As for my approach for judging, I want to just tell you a brief story about the summer of 2007, as I was preparing to serve as lead counsel in a very rare death penalty trial here in Brooklyn, representing James McTeer from Brownsville. Now, you may ask yourself and say to yourself, well, New York doesn't have the death penalty, and that's true, but the federal government has the death penalty. And I represented a client who Attorney General Alberto Gonzalez authorized for seeking death. 4 months before trial, I flew to California to spend 8 days studying at the University of Santa Clara Law School's Death Penalty College. Santa Clara is a Catholic university, and they are institutionally opposed to capital punishment. And every summer, they invite every lawyer in the country with an upcoming death penalty trial to fly into Santa Clara, to bring their file, to break into small working groups of 8, and then to put every aspect of their upcoming death penalty trial. Because, as the Supreme Court says, death is different, and death penalty trials are different. Jury selections, opening statement, closing statements, cross-examination, mitigation cases, mental health issues. The list of issues in a death penalty case seems endless because the task is so enormous, because you are the advocate literally standing between your client and death. Now, Ed Wilford was a New York lawyer who led our small group, and he taught us how to gain our bearings and how to move forward with this most awesome task that was before us. Ed was a proud son of Harlem, a fierce advocate, a gentle giant, and he's left us too soon. But day in and day out, he would drill into us that if we learned nothing else at Santa Clara, it was that we must always walk in our client's shoes, because our clients' lives literally depended on it. Walk in somebody's shoes, he said, and understand the world. And Ed's lesson in bearing the enormous responsibility of defending James McTeer from the death penalty had and continues to have a profound effect on me. I know that it helped save James's life, and it has informed my approach to every person I've encountered in court cases ever since, including as a judge, to judge from a perspective of empathy, true empathy for others. And I find that this approach is often the key that unlocks the door to a just result in my cases. That's pretty dense stuff for 2 minutes, and I'm going to pipe down now because I know you have questions, but I wanted to share that with you because I believe that it explains to you why I believe I am a good candidate for Supreme Court. I hope that I'll have your support. Thank you.
Thank you, Judge Perlmutter. And I guess I'll open it up with the question. So you did talk about restorative justice. So I wanted to ask if you could elaborate on a time where you've used it. and seen it to be a successful tool in the courtroom.
So I use it every day in my courtroom because I sit as the DWI judge in Brooklyn. And when I came to the DWI court, there was no real rational approach to how the cases were structured for pleas. But one of the programs that was available in my court was a program offered by Mothers Against Drunk Driving called the Victim Impact Panel Program. And what that program does is it brings victims of drunk driving accidents or the families of people who died in drunk driving accidents and has them sit for 2 hours with people who have been convicted of drunk driving offenses to explain to them what their actions could have resulted in their own lives. And I require that in every one of my cases, no matter how minor or how serious. I make everybody go to the Victim Impact Panel Program. And it has been transformative for people. Each and every day, people break down in front of me and tell me that that was the most important 2 hours that they've ever spent, that they have had an awakening in their lives about the impact of their actions on the lives of other people and how grateful they are that their lives didn't wind up the way that people that they heard from wound up. And it's an incredibly powerful tool. And what I look forward to in Supreme Court is bringing restorative justice approaches to far more serious and difficult criminal cases than I'm dealing with now, because it is a very, very powerful tool that we are just beginning to understand how to use.
Thank you. So I'll open it up to any leaders. Any questions for Judge Perlmutter? And pass it to Leader Naplatarski.
Hello, Judge Perlmutter. Thank you.
Hello,
Here.
District Leader Naplatarski is my district leader, in case you want to know that.
Yes. So I'm going to just pop into the Facebook and ask a question that was asked by Yomi.
Sure.
And I believe this might have been for previous judge, but it is a good question, so I'm going to ask it of you. And the question from Yomi is, do you believe that all citizens have adequate access to legal help and the legal system? If not, what can be done to provide wider and better access?
Well, in an answer, I mean, the short answer is no. You know, we have, there's desperate need for more legal resources for people who aren't represented. And, you know, it's not only in New York City, but it's throughout New York State, where there has to be an emphasis on providing more resources for lawyers and for other resources as well. You know, one of the things that's been interesting in the advent of bail reform is that New York City has finally really worked to scale up pretrial services so that people can be released and supervised and have programs and services that may assist them, very much the way Judge Swearin was saying. You need to try to target the root cause of why somebody's in the criminal justice system, and then approach that root cause with strategies. And the only way to do that is through resources. And the fact is that we don't have enough resources. And you know, that's really not something that the courts can fix. It's something that's got to be fixed in state budgets and in the legislature and in the city budget and the city council. But there's always a need for more resources. And it's just not in the criminal realm, it's also in the civil realm. Providing adequate resources for families in family court, or people who are in landlord-tenant court, who are facing eviction. I mean, there are now more resources to provide them with counsel, but it's not enough. We need more.
Thank you.
And 30
sorry,
seconds.
I just wanted to ask a question on Leader Pierce's behalf. She had a question regarding your questionnaire and regarding your philosophy on judicial activism. You mentioned the judge should think creatively and understand the law's ability to change over time.
Sure.
And can you give us a specific case or example where you applied this principle and share details with us?
Sure. and I guess I'll try to keep it limited to my my position on the bench. All right. So, for example, in the DWI court, I have many undocumented people who appear before me, who are deathly afraid that this case that they have before me is going to result in their removal from the United States. Some of them have been here for decades and have been arrested for a relatively minor offense with no accident, no injuries, and they are in fear. And so what I did is from the day I took the bench, I instituted a practice that everybody thought was strange, which was that I would not let anybody approach to conference cases with me at the sidebar. And it's not done in state court. In federal court, you're not allowed to approach at sidebar, but in state court, lawyers always sit at come up and they pal around with the judge, and then they come back and they go on the record, and everybody always wonders, what happened at the sidebar? And I decided I'm going to take a different approach. I'm not going to allow sidebars except in two instances. One is if you have some type of medical information that should be protected from the record under HIPAA and should not be disclosed publicly. And so I tell people, if you have health information, then approach by all means. Or if you have what I define as a legitimately held security concern for any stakeholder within the proceeding, then you may approach and discuss that at sidebar. And lawyers quickly realized that that was code. That meant if you have somebody who's undocumented, you come up and you tell me at sidebar that that person is undocumented. And then from there, I have creatively used a whole host of laws to be able to move those people responsibly through the criminal justice system, often with no criminal record, and in a manner that protects them from undue collateral consequences as a result of their conduct, i.e. facing the risk of being deported. So for example, in New York State, misdemeanor cases can be handled completely by affidavit. Sometimes I use that, sometimes I don't. In my courtroom, I have an open advancement policy, which means that on agreement of a defense attorney and a prosecutor, they can call my clerk and advance any case to any date that they wish. And the advantage of that is it allows for random calendaring of cases involving people who are undocumented. So they can't be tracked by other people that may be interested to know when they're going to be in court or not in court. And so there are a whole bunch of tools. The other thing too is I do immigration safe pleas, and I do them in a manner that has withstood review by the appellate courts. And it allows people, again, to receive treatment, go through restorative justice, learn their lesson, and at the same time, not risk that this case is going to completely destroy their lives and the lives of their families.
Wonderful. Thank you, Judge Adam Perlmutter. And we will now move along to Judge Joy Campanelli. So please, Judge, 2 minutes intro. Questions? Oh,
I'm sorry. You know, I always mute myself because we do a lot of virtual proceedings now, not just with attorneys, but with self-represented litigants. And I'll tell people, if you're not speaking, please mute yourself because we get all the feedback. So I apologize for that, but it's just a habit from being in the courtroom all the time. With that being said, I want to thank the district leaders. I want to say hello to my colleagues. I know Judge Swerin and Judge Perlmutter. I think we may have met a couple of occasions. I am a supervising judge of Civil and Housing Court in Richmond County. I know that you did get the questionnaire, and I'll just speak a little bit about my background. Before I ascended to the bench, I was a practicing attorney for 10 years in civil litigation. I was a civil trial attorney. I then, in 2003, became a principal court attorney to a Supreme Court judge, and I held that position for 11 years. And that was Supreme Court in Brooklyn, the court that I'm looking to get the nomination for. In 2014, I was on the ballot. I was elected. I started my term January of 2015. And initially I was assigned to criminal court, which was a challenge because I had no criminal background at all. I wasn't the only judge that found myself in that position. All of the judges that were elected the same time that I did were sent to criminal court. It was a great experience in the fact that I learned a whole new area of law I never would have learned if I hadn't got sent to criminal court. I was there for 2 years, and then I was sent to 141 Livingston Street, which is civil court in Kings County. And I served there for about a year and a half. And then in 2018, I was promoted to supervising judge of housing, civil and housing court in Richmond County. And I'm the only supervising judge that wears 2 hats, so to speak. Every other civil court has a housing supervising judge and a civil court supervising judge. Becoming a supervising judge, you also become an acting justice of the Supreme Court. Unlike other supervising judges, I not only just have the title. When I got to Staten Island, they actually had a Supreme Court part set up for me that I would get cases directly from Supreme Court Richmond County that included jury trials, conferences, pretrial conferences on a whole different manner of cases. So when I got to civil court in Richmond County, obviously I don't have the experiences. I'm going to be talking about the civil aspect of things. And basically in civil court, we deal with a lot of self-represented litigants. We deal with consumer debt, which is the consumer debt part, which is credit card cases. We deal with small claims. We do have 2 attorney cases. And as was said before about representation, probably civil court in the consumer debt is one of the aspects in the court system that you don't automatically get an attorney to represent you. I know in criminal, there was always legal aid, there was 18B, there was Brooklyn Defenders, even at an arraignment, if you didn't have somebody, legal aid would stand up. In housing, when I went to housing, I had to implement the universal access. I had to find space for the providers in order to provide representation to the tenants in landlord-tenant. Now in Staten Island, and I believe across the city, every zip code, you can get an attorney to represent you in your L&T case. In consumer debt, we have lawyers for the day who come in and talk to you, and we have providers that I can refer litigants to who can help them and aid them in drafting papers. But when push comes to shove and you have a trial on a consumer debt case, there's no attorney standing up with you. You're on your own. And, you know, that's the reality. And I just wanted to lead on that question because you asked about representation. So that is actually a very big challenge, and especially as a supervising judge, to make sure that the self-represented litigants have knowledge and awareness of the services that are provided to them and that they have the time to consult with these providers. So when I got to Civil Richmond, I did implement certain changes to the parts for the self-represented to make sure that they had a better understanding of what was going to happen to them that day. Because I'll be honest with you, watching the part before I started, I went a little bit earlier, people walk in, they're terrified. They don't know what's going to happen to them. They don't know who to talk to. And I made certain changes and had certain announcements made and had the court start a little bit earlier so that the self-represented litigants had people that they could talk to who could give them information. I would also go out myself and introduce myself to the self-represented litigants. And I would, make a speech about who everybody was, what they can expect that day. I asked my judges to do that also, to go out before the calendar call, let the people see you. I couldn't force them to, but I made sure that announcement was made. And of course, I couldn't sit in that part every day because I have other administrative duties to do and other parts. And that was going along really well. And I had put down as one of my achievements, obviously COVID hit. And then I had to navigate a courthouse through a pandemic, making sure that individuals who would face income executions and wage garnishments had access to lift those stays and to get before a judge. Because if you remember, a lot of the legislation that came out during COVID dealt with tenants, and rightfully so, dealt with mortgage foreclosures, and rightfully so. But you didn't hear anything about the consumer debt litigant there were no stays for those litigants. And that was when the administrative judge and the supervising judges had to implement policies to make sure that those individuals were able to have access to justice. And also another thing that you never hear anything about that happened that we had to worry about were illegal lockouts. There was no legislation preventing a landlord from illegally locking out a tenant. And we had to worry about that as well and make sure that those people had access to justice. So that was being a supervising judge. I will tell you, COVID has transformed how the courthouse is run. We keep the footprint low, but I'm pleased to say that we're hopefully opening up, and nobody was ever turned away, even with minimal staffing. And we had to relocate because we had a COVID death in our courtroom. Individuals were able to get orders to show causes signed. They were able to get stays lifted. They were able to get before a judge if they had an income execution or a wage garnishment. So now we're in that. I also was responsible for the citywide policy, re-implementing small claims. Small claims is often forgotten about, but it's where a lot of self-representatives can go to get justice with a very informal way of bringing a case. It's very reasonably price-wise. You don't need an attorney, and the rules of evidence are very relaxed. And it's really a more simplified way to bring a case. And a lot of people use small claims for money that they believe that they're owed, and that could really help them. And I was responsible during COVID. I co-authored the citywide small claims policy to re-implement and reintroduce small claims so that individuals can have their cases heard. I'm down to 2.5 minutes. I kind of went off on a tangent. So I'm going to stop here because I'm sure that you have questions. Or if not, I could just keep going on. So
Thank you.
Okay, you're welcome.
I'll ask this question that I think was probably for another candidate, but it's a good question. And so it's in your various roles over time, has your perspective changed? And if so, what do you attribute it to?
Okay, I'm sorry. Could you repeat the first half of that question again? I'm sorry, I missed it.
Yes, in your various roles over time, has your perspectives changed? If so, what do you attribute it to?
I mean, my roles as an attorney, a principal court attorney, and
Yes.
as it just go. Well, when you're a litigator, you're an advocate, and you have a certain role. And I will tell you one thing, when I was an advocate and I did civil, I didn't do criminal, and say I had a motion for summary judgment on threshold. And I was a defense attorney and I wanted that plaintiff's case dismissed and I didn't get a ruling. I'd say, I can't believe this judge didn't rule. How could this judge? But you know what? When I became a judge, I thought a little bit differently because now I'm going to throw somebody's case out. And it's not so easy. You to really look at the law, look at the evidence, look at what they're putting in that motion. So from an advocate to going to the bench, definitely, because when you're an advocate, you're in a different head, and that kind of also probably changed when I became a principal court attorney because I worked very closely with the Supreme Court judge. And you have to remember, you're not an advocate. You have two parties that you're the neutral arbiter of the controversy that brings those parties together. So of course, my perspective changed as from an advocate to going to the court system and then behind the bench because they're weighty decisions. And I think as an advocate, you just always think, oh, that judge, oh, I can't believe that judge. But then when you are the judge, you're like, oh, geez, yes, I can see this now. So I think that's how my perspective has changed.
Wonderful, thank you. I guess that's time.
Yes.
So I'll pass it along to District Leader Pena.
Thank you. And thank you, judges, for joining us. I am going to throw the link in the chat if you'd like to continue watching on Facebook. But we'll be moving to the next round of candidates. Sorry, trying to multitask there. So thank you for participating. We appreciate it.
Thanks very
Okay,
much.
thank
And I
you.
just wanna
Thank you
say
for
one
hosting.
thing. If you guys want to come see me in court, anyone can contact me and I can Skype you in or Zoom you in, and you can watch me in court if you'd like to see me in action. Thanks.
Now, I'm going to throw out the same offer, but I'm going to throw it out specifically for if you want to come and watch arraignments and see how the new bail law is being implemented. You may find that very, very interesting. And so let me put that out there as well. Thank you, everybody. Have a good evening.
Have a good night, everybody.
Thank
Good
you.
night.
Thank you.
Gotta go.
Great. So we have Judge Carolyn Walker Diallo joining us, Judge Demick,
Yes.
and Judge Abadi. Welcome and thank you so much for your patience with us this evening. We are going to get started. We'll have a 2-minute introduction with each candidate, and we'll throw it out to some questions from leaders, and we'll go candidate by candidate. My fellow district leader colleague, Jesse Pierce, will be our timekeeper. So I'd like to turn it over to Judge Walker Diallo. Please feel free to give us an introduction.
Good evening. Can you hear me?
Yes, we can.
Okay. Thank you so much for the opportunity to speak with you today about my candidacy for New York State Supreme Court, Kings County. Just a little bit about myself. I was born and raised in East New York. I live in the Cypress Hill section of East New York. And I live in the same house where I grew up. I attended the area schools, PS 290, IS 302, Franklin King Lane High School, when it was one big school. And upon graduation from Lane, I attended Lincoln University in Pennsylvania, the first HBCU where I majored in business administration and political science. Upon graduation from Lincoln, I came back to New York, worked for 2 years doing computer science. Prior to year 2000, working to reprogram software so the computers wouldn't blow up. That's what we thought back then, right? And after 2 years of that, I pursued a joint degree, my law degree at New York Law School and my master's in business administration from Baruch College. After obtaining those degrees and passing the New York State Bar, I began to practice law, and my legal experience is pretty diverse. I worked at a large law firm at the New York City Law Department. I operated my own practice, focusing on pro bono representation and representation of nonprofits. I served as an administrative judge, and immediately prior to taking the bench, I served as general counsel and chief compliance officer of the oldest nonprofit in Brooklyn, Brooklyn Community Services. At the same time, I was very active in my local community, serving as the first vice chair of Brooklyn Community Board 5, a chair of a CB5's Economic Development Committee, a member of the 75th Precinct Council. I served as a judicial delegate, an alternate delegate. I served on the board of several nonprofits, and currently I serve on the board of the George Walker Jr. Community Coalition, which is a nonprofit in East New York. And our flagship program is the East New York Youth Court, where we work with high school students at the Thomas Jefferson High School campus to expose them to the legal profession. As the supervising judge of Kings County Civil Court, the People's Court, the busiest court in the state, if not the nation, I remain dedicated to ensuring equal access to justice to our borough's most vulnerable populations, including the self-represented, and aspire to bring all of my skills, experiences, and abilities to the New York State Supreme Court. I will stop there because it's an occupational hazard that we can talk all day as lawyers and judges. But once again, thank you for the opportunity.
Thank you so much, Judge Walker Diallo. Do we have any questions from leaders? I'll throw in a question from earlier that someone threw in from Facebook. Is there a book that you read recently that has changed your perspective on the world, that has changed your world perspective?
A book that I read recently that has changed my world perspective. I would have to say there's a book that I read called Brainwashed, and I read it over and over again because I work a lot with young people, really focused on media. It's an older book, so we really read it to really talk about how social media impacts our community, specifically Black and brown communities, and the impact that marketing, the media can have on not only how we view ourselves, but how others view us. We talk a lot about implicit bias and how that impacts all of our lives, especially within the criminal justice system and within the justice system as a whole. So that book has been really instrumental in helping me to really sit back as a judge and be cognizant and aware of things that I take in and how that may impact me when I am doing my job, and how to best serve the people of Brooklyn, and making sure that when people come to court, whether they're represented or unrepresented, that they get equal access to justice, they get notice and an opportunity to be heard.
Thank you. We have a question from Leader Naplatarski.
Hi, Judge Walker Diallo. Thank you so much for joining us and for speaking to us. Thanks. So I'm wondering, in your questionnaire, you spoke about how you believe that justice is best served with a component of compassion. And so I'm wondering if there are any ways in particular in which you try to bring that compassion to the courtroom.
Certainly. So, I'm aware, and I have experienced even before I became an attorney going to court with family members, that going to court is a scary experience for a lot of people. Even as an attorney, it was scary for me, depending on which judge was sitting there, right? What was happening. So for me, I'm cognizant every day. I sat in criminal court first and then in civil court. I'm aware of what the experience may be for a lot of people coming to court. They're afraid. They don't know what to expect. Some people don't even know why they're there. And so they need someone to explain to them why they're there. So with compassion and really trying to put yourself in someone else's shoes, what would I think or how would I feel if I had to come to court not knowing anything, even if I have an attorney? And sometimes when people have counsel, you can tell that they're still confused as to what's going on, right? So I listen very carefully. I take nonverbal cues. I explain. I go to the default, especially with self-represented litigants, that they have no clue why they're there. And I explain to them. First, I smile, right? I say, I know you're scared, but do you know why you're here, right? And then we start that conversation as to why they're here. When it was in criminal court, they're arrested, what they're being charged with. They have counsel, right? But what they're being charged with, if it's in civil court, why you're here. Do they need an attorney? Would they like to speak with someone, giving them the opportunity to speak with someone, even if the other side is complaining that, we need to move this case forward. But if it's a self-represented litigant, a lot of times, they just don't know what to do and where to go. So the compassionate part of it is really trying your best to step into their shoes and feel what they're feeling. And I try to do that every day as a judge.
Thank you.
You're welcome.
We have a question from Leader Pierce, who's having some audio issues. You mentioned in your questionnaire and accomplishment, your ability to move through your caseload, and how do you balance both expedience while making sure that people before you are treated respectfully and their case is handled?
So the civil court is, I said, the busiest court in the nation. So we have a lot of cases that we have to get through, and we have a docket that we have to get through. So part of it is two things in the civil court. It's using the staff that you have, like I have a court attorney. So at first I'll have my court attorney kind of conference cases so I can get understanding of what's going on. But I also make sure that they come before me and I speak to them. I think it's important. A lot of times I look at the cases before they're on the docket to really get a feel for what's going on with the number of cases that I have, so that I'm briefed, I'm aware of what's coming before me, so that I can present myself to the people and explain to them more succinctly what's going on, what's going to happen. But I think a part of case management, court management, is really using the clerks, the court attorneys to help you move the cases. But in the end, as a judge, you have to know what the case is about, to know the law. That's very important, right? And to be able to succinctly speak with the parties so they know why they're there, what the case is about. And it's hard sometimes when you're dealing with self-represented litigants, because they come to court and maybe it's the first time they've been to court and they want to tell you everything, about their life, about the, and it may not have anything to do with the case. So being able to get the information that you need from both sides in a compassionate way, in a respectful way. But I think part of that is explaining to them, I understand this is the first time that you're here and you want to tell me everything. And I want to hear. But in order for us to move forward, right, and for you to be able to leave before 9 o'clock tonight, this is what I need from you. Can you help me do that? And more often than not, with pro se litigants, they'll give you exactly what you need in order to help the case move forward. I hope I answered your question. Okay, yes.
Thank you. And we have a question from Leader Boykin.
Yes.
Shaquana?
Sorry.
There you go.
My question, first, nice to see you in person.
Likewise.
But my question, I love your questionnaire and just like reading about just like how you're passionate around integrity and just like really meeting people where they are. And you have spoken a lot about that. But I guess my question is, how many times have you ran for this position? And within running for this position, have you gained new knowledge or experience about just like Brooklynites in the community?
So so for Supreme Court specifically, correct? Okay. So the process that I have gone through, I believe in 2019, I submitted that's the first time I submitted my information to the Kings County screening panel, and I came through that year, but I didn't seek the nomination strongly. Last year was the first year that I did. So I came through twice and was approved. And last year was the first year that I was able to make a good run for it, right? Didn't make it, but I'm back this year. In terms of what I learned about Brooklynites, look, I'm a Brooklyn girl, born and raised from a specific section, but I have met so many people from across the borough. And the one thing Brooklynites want, and I think we all want, is a court system that works and that is functional, a court system that is for the people, that is by the people, judges who represent the community, the cross section of the community, judges that are going to listen, judges that show up on time, judges that know the law, right? And judges who really understand what it means to fulfill our constitutional obligation, right? To adjudicate the cases as swiftly as we can, while at the same time making sure each step of the way that the system is balanced and even for everyone. And it doesn't matter whether I go to East New York or Bay Ridge, it doesn't matter. People want the same thing. So that's what I have learned, and it's comforting, right? Because sometimes you think we're such a large borough and we're so different from different backgrounds, but we all want the same thing and we deserve the same thing.
Thank you so much.
Thank you, Ms. Boykin.
Thank you. And that is time. I appreciate your responses very much.
Thank you so much.
And now I'd like to turn it to Judge Matthew Demick. Please feel free to give us a introduction, and then we'll go to some questions.
Okay, thank you. First, again, thank you so much for giving me the opportunity to appear before you like this. I mean, I wish it could have been in person, but there'll be time in the future for that. And I guess what I want to say to you is that, I was appointed to the Court of Claims and assigned to the Supreme Court in Brooklyn 25 years ago. Actually, Sunday is my 25th anniversary on the bench. And I decided to seek a Supreme Court nomination because it would be the only opportunity I could have is to continue my work for an additional 6 years as a certificated Supreme Court judge. And let me tell you why. I mean, I've been writing to you. I don't know if you got my second correspondence, but I've been the luckiest state court judge in creation. I was appointed, I was assigned to a regular criminal term. I try to be an efficient docket manager, move my cases along expeditiously, again, making sure that due process was assured. But a year into my judgeship, I was asked by the administrative judge at the time to be the second judge in the first specialized felony domestic violence part in New York State, the Brooklyn Domestic Violence Court. And what happened about the year I was appointed, 2 women were murdered by their abusive boyfriends while they had orders of protection from the court. And the chief judge and the press and the public wanted to know, how could this happen? How could these women be murdered while they were under the protection of the court? So it was thought at the time that if we had judges that would see the case from beginning to end, that had some specialized training, some additional resources, that would be a way to ensure that this didn't happen again. And actually John Leventhal was the first judge of the part. I took over half his caseload, and my job changed immediately. Instead of being an efficient docket manager, I had to make sure that societal peace was maintained, that everybody was protected during the pendency of the action, and of course that due process was accorded to the defendant. So rather than be efficient, I would have defendants that were not on bail or their own recognizance come to court much more frequently, so that I could know that the order of protection was not being violated, that status quo was being preserved, and still the case was being moved on. And I would have to say that in the 22 or 23 years that I've been doing that, thankfully, there hasn't been any serious injury or murder of anybody that was before me. But I believe that I have had the ability to impact society and impact individuals in a very beneficial way. Now, that's not enough. In 2002, the administrative judge asked me to take on the additional assignment of being the judge in the first mental health court in New York State, which is a court that is geared to give people living with mental illness a second chance. So the criteria for the court basically is that you live with a serious mental illness. And I would define that as bipolar disorder, major depressive disorder, schizoaffective disorder, or schizophrenia. And there doesn't have to be a direct contact with the criminal behavior. Loose contact is enough. And the idea is that we keep people out of jail, we keep people out of prison, we put them into, treatment, on medication. And the court mandate is basically a year to a year and a half. And for a misdemeanor or first felony, the case will generally be dismissed. If it's a second or third felony, then it may be probation, misdemeanor probation, or conditional discharge. But in October 2019, we had our 1,000th graduate. And we had a little bit of a ceremony, and it gave me the opportunity actually to have defendants come back to court and speak about the effect that the court has had on them. And actually, with my second correspondence to you, I included some of that to give you a fuller idea about the scope of the work that I do. So, here I am. I have these 2 great assignments where I have the ability to impact directly people's lives. Now, 7 years ago, I was asked by the chief administrative judge of New York State to take on the additional assignment of being the administrative judge for criminal matters in Kings County. And, believe me, during the pandemic, it's really tested everybody's ability to keep the court system moving. But I'm proud to say that under my leadership, we were able to get up and running virtually very quickly. The Department of Corrections has put up booths and in the beginning of the pandemic, of course, we were getting hundreds of writs of habeas corpus to have people released from jail because of the fear that they would get sick. So I've also, pre-pandemic, worked with the Center for Court Innovation, put in some innovative programs. Brooklyn was the first court to use, to generally use in this arraignment part that I set up, unsecured and secured personal surety bonds, personal appearance bonds before bail reform. And a study showed that had reduced processing time 12% for the people that were appearing in the Brooklyn Supreme Court. I'm not sure if my time is up. Okay. So
we have about 5 minutes.
I have about 5 minutes. So there are, my wife just hands me a note saying I'm talking too fast. I'm sorry if I'm talking too fast, but this is the way I talk. The other reason I would like to continue doing what I'm doing is that I've developed over the past 25 years certain expertise. And, you know, most people are very familiar with the civil side of the courthouse, and nobody really concentrates on the criminal side. But for example, I'm involved now, Chief Administrative Judge Marks asked me to participate in a task force established by the National Center for State Courts, the national organization, dealing with the state court system's response to mental illness and criminal justice. And the subcommittee that I'm on at this point in time has to do with competency for stand trial. Now, I would say that most of you probably don't understand what fitness to stand trial is. I mean, they skim over it in law school, right? But it becomes important because you have people who are living with a mental illness, caught up in criminal justice, and a judge or an attorney or a DA feels that they don't have a rational understanding of what's going on in the proceeding or can't participate in their own defense, then they are sent for what's under Article 730 of the Criminal Procedure Law in New York for examination by two mental health professionals to see if they can be restored to fitness. Now, how this becomes important is that a person living with mental illness caught up in criminal justice is really not someone the adversarial system is geared towards, right? I mean, it really doesn't work for them. And if you're keeping them locked up either on Rikers Island or in a prison hospital, basically, for restoration of fitness, we have to make sure that this is done quickly, efficiently, that there are sufficient professionals to do the examination. And when they are restored to fitness, perhaps get them more help than just understanding the players in criminal justice. And I can give you one example with that, and I'll finish there. When we started the mental health court in 2002, it was decided that individuals that were sent for a mental health examination to determine whether they were fit for trial would first come back when they were fit to the mental health court, because it was some indication that maybe this was a person that could be helped without going through the traditional zealous prosecution and give them an opportunity to get into treatment and get out from under the criminal charges without bail. So I guess what I'm going to close on is saying that I've developed this expertise. I do have a national reputation. The Scottish government asked me several years ago to go there and talk to them about both domestic violence court and mental health court. And I've had visitors from all over the country and common law countries actually coming to visit the court. So look, I am an extremely lucky judge. I didn't make any of this stuff up. I was just asked to do the assignments, and I'm very grateful for it.
Thank you, Judge Demick. We have about 1 minute. I just want to see if we have any questions from leaders. I had a quick question. I was very intrigued about your work on the mental health court, and I'm wondering how you see that the work done in that court system translate to Supreme Court.
I'm not quite sure I understand the question. I mean, it is in the Supreme Court, right? The mental health court.
Okay. I thought it was in the. Sorry, I misunderstood. I thought you said the Supreme Court.
What it is that it's a court part. The court part is called MD1 in Brooklyn, and then there's also MD2 with a different case management agency, but it's part and parcel of the Supreme Court. I'm lucky enough to have a clinical team, so I work with social workers every day, and you know, and I know my time's up. I don't want to take too much time, but it's part and parcel of the Supreme Court. But one other thing, after I just lied and said I was going to finish, I have just established an alternative to incarceration part of Brooklyn in partnership with Brooklyn Justice Initiatives. The pandemic kind of delayed it a little bit. I mean, we have some cases, but my idea of this part is to bring things like the drug treatment court, the mental health court up to scale. So in other words, we are trying to identify young people, say 18 to 24, could be older, but that's where we're concentrating in the beginning, to see, and it just doesn't have to be a drug problem, a mental health problem. It could be poverty, it could be lack of community support, lack of family support that got them caught up in criminal justice. So my idea is this can bring the idea of problem-solving justice up to scale and continue the work we're doing, but for a broader populace of individuals that we could keep out of jail.
Thank you. And thank you so much for participating. We're very much appreciate it.
I appreciate it. Thank you.
And now I'd like to introduce Judge Gina Levy-Abadi. And you have a 2-minute introduction, and then we'll go to some questions.
Okay, I just want to thank you all for inviting me here to speak about my experience and my knowledge. It's greatly appreciated just to have a forum to do that so you know more about me. I'm going to start with my experience, my work experience. I worked for a civil court judge for 6 years. I worked in civil court in Brooklyn, and eventually I worked 12 years for that same judge in Supreme Court. The various parts we covered what's called like the TAP part, the general part people go to settle. I tried to at least settle cases so they wouldn't have to go to trial. I do have trial experience as well because we also tried cases with my judge. I prepared most of the jury charge. I have experience conferencing cases, as well as I sat as an arbitrator for 10 years in small claims court. So I have 10 years as an arbitrator listening to small claims court, working for a court. At least the ability to work outside the court system is non-existent because they don't want you to have a conflict. So I wasn't allowed to do other pro bono work, but I was allowed to do that. So I did that. In addition, some of the other things I do is I coach a high school mock trial team, which I've been doing for 20 years to give back to the community because oddly enough, when it was my mock trial coach that encouraged me to pursue law. And I'm hoping I went back to the school to give back to those kids. I intended for it to only be a few years, but it's 20 years later and I secretly love it. What else? I'm going to tell you about my time I became a judge. I ran a contested election. I won, luckily, and they put me in criminal court where I had no experience because 18 years I spent doing civil law. But I read up on the law. I did arraignments. At one point during the pandemic, the supervising judge tapped me. He said, you have unique skills because you were in civil court and you were in the JCP part, the settlement part. He said, I'm going to give you an inventory of 4,000 cases. I took those 4,000 cases. I disposed of 3,500 of them. And just to give you an idea of what the courthouse was like at the time, I was one of the first judges after the pandemic hit and the court closed down. I worked for 10 days straight. This includes Saturday night and Sunday. I worked 10 days straight, and at the point where we were allowed back in the building, we didn't even necessarily need to go back into the building, but I did go back in the building. My law secretary and I put on sneakers so we could run to pull the files ourselves because we didn't have staff. So 3,500 cases were disposed of by me. I either took pleas or heard motions or did something else with the case, but I got rid of most of the backlog. And again, by some of the stuff we had to do ourselves, I came and I hand wrote on all the paperwork so the clerks could enter it so we could save time and not do it via Zoom. But I did do that. Personal background, and now I'm in civil court. Doing what I did as a law secretary for 6 years, I'm doing as a judge. A personal background, I'm an Orthodox Jew. It was unconventional. I'm I'm going to be honest, most of the kids got married at age 16 out of my school. It's a big deal that I'm here. It's a big deal in my community that, forget about going to college, going to law school, becoming a judge is unheard of. My mother is a Syrian refugee. She escaped Syria, and my father escaped Egypt. They weren't allowed to practice Judaism. Oddly enough, my mother went to Catholic school because there were no Jewish schools. So she was taught by nuns, but she's an Orthodox Jew as well. But in high school, I don't want to say that they didn't even discuss college with me. They thought I was going to get married and have children and do what everybody else is doing. And that was part of the reason my mock trial teacher inspired me. I went back to the school after 20, I think I'm doing it for 21 years. I have my first female student go to law school, which it took 21 years, but I finally have my first student going there. That's one of my accomplishments, I think, because giving back to the community is important and just opening their eyes. But hopefully I'm doing that. If you have any questions, I'm happy to answer them.
Thank you. Do I have any questions from leaders? And I see Leader Bazile.
Hi, Judge. Thank you for taking the time this evening. So this one question is from Facebook, and it reads, we live in such polarizing times, and higher courts' decisions have played a role in furthering this polarity. What would you do in your role to help heal the divide?
I have to tell you, when I like to be consistent, and when I see things are going on in my courthouse that are not consistent, I think that we need to change that. So meaning if there's an offer for one party and not for the other party, with respect to a settlement, I have a dichotomy. I have two different things going on. And I said, we're not going to do that. What could we do to make this more even? I try to administer justice evenly to everybody. And if I see different things going on that shouldn't be going on, I try to correct it as a judge. I try to bring everybody onto the same page to at least administer justice in a way that it's equal to everybody that's there. I hope that answers the question. I can give specific examples of things I see that are, I want to say dividing, but there's also, generally speaking, it's the decorum in the courtroom. It's the way people are talking to each other. I mean, I'll stop and yell. I said, we're not going to do that, where they're talking down to somebody. I've had female attorneys being spoken to. I mean, they're fresh out of law school, usually working for the DA or legal aid. I said, we're not going to do this. We have two different things going on here. And I said, we're not going to talk to each other like that. We're not going to do this here, not in front of me. And everybody stops. So I try to do what I can. Just having a robe on sometimes. The judge I used to work for, I used to, whenever I would tell him, I told the litigants this and they didn't believe me. He says, it's different when you have a robe on. If you say, I could say the same thing you said and they'll listen. So I try to, now I have the robe on and I said, we're not going to do this. We're not going to talk like this to each other. We're not going to be disparaging to each other. And it works. It's amazing. It works.
Thank you.
Thank you. And we have a question from Leader Boykin.
Hi, Judge. So
Good
nice
evening.
to see you.
Nice to
Good
see you.
evening. Sorry, I'm cooking. I have like my
No, you got to do
my
what you got to
cooking shirt
do.
on. But I have a two-part question. I love youth. Like anytime I hear people talk about youth, I'm like, oh my God. So you got my attention. So now that you have my attention, my question, I heard you say something about someone got into law school or something like that.
So if I told you where I was from, you would think it's another planet, honestly, because the women, I don't know if you want to hear about this, but
Are you from Brooklyn?
You can't tell from the accent, but I was given marriage classes in 12th grade. I had marriage classes that came out of, I'm not going to get into the Hebrew scriptures, but we had marriage classes, what to do for your husband, and what is he going to do for me? And that wasn't the focus on it of that. So I decided to come back. I made it out for whatever the reason is. And I said, you know what? When I called up my mock trial teacher and I told her, what would you like me to do? I want to buy you a gift. I want to do something nice. Gina, go back to school. I said, what? She says, go volunteer to help the kids. They don't have a teacher anymore. They don't have a mock trial coach. Next thing you know, I'm in the school. I'm mentoring them. I'm in the school. This is like, I'm spending 10 hours a week at night on this. The kids come to my house. I end up feeding them. It turns into a whole nother job that I didn't know I was going to have. Some of the men have gone on to law school. I couldn't get one female to go on to law school. 21 years, I couldn't get a female. And the one possibility, she called me up. She says, Gina, I'm getting married. I don't know whether I should get married or go to law school. And I said, you could do both. She finished her first year. Honestly, I don't know if she's going to continue because there's a lot of pressure to have kids, but I got her to finish her first year of law school. I'm so proud of that because it was one female that I got out of 21, but if she goes back and does what I did, it's going to roll. More people are going to be affected.
Thank you for that. I know we ran out of time, but my second part of the question really quick is like, knowing what you know, just like having that great experience with that young person, how long have you been in civil court, and would you refer a young person to civil court as well?
Refer them to work, you mean?
Yes.
So
yes.
I've been in lower civil for 6 years and upper civil for 12 years. Not only would I refer them, I've invited classes to come watch me, to come watch other judges. You know, it's not, and the diversity part of it is important to me. My law secretary is Latina and she's fabulous. But I say, don't just come watch me because you see other people like me. I mean, you've seen people like me in your school. You're going to go watch the judge next door. I've asked other judges to talk to them that are different judges in the building, and I've invited them to come work for me. And there's been many people that have come to intern, to watch the courtroom proceedings. They don't even realize it's open. You could talk, or I did arraignments. You could come watch on Zoom. It's open. Everybody should experience it. And whenever we do something in court, I make sure to talk loud. I make sure the audience, it's not just my audience of everybody can hear and see what's going on.
Thank you.
I thank you for having me. I know it's late. Thank you for listening to me.
No worries. Thank you so much for joining us, and thank you to our candidates for sharing with us. We very much appreciate it.
Thank you.
Thank you.
Thank you for having me. Have a great evening.
You too.
Appreciate it.
Thank you.
Bye now.
And for those who are watching on Facebook, thank you so much for sticking with us for this amount of time. We will be holding a second forum in the coming days for some additional candidates. Stay tuned to our social media and email for the date. And we hope everyone has a great night. Thank you.
Thank you.
Thank you.
Good night, everyone.
Good night. Good night. Stay safe.
Good night.